Welcome to the First District Court of Appeal. Before we get started, I want to congratulate Judge Treadwell on his appointment to the bench. He was appointed in May, so we've been serving together for a few months now, but today is his first set of oral arguments. So congratulations, welcome. It is indeed an honor to serve with you.
Thank you, and counsel, today I may be more nervous than you are.
Fair enough. With that, we will turn to our docket. We have two cases today. We will take them in the order in which they appear on the docket. First up is Mavis Tire and Brakes and Liberty Mutual Group versus Albert Lowry, 242458. Counsel for the appellants, you may proceed when you're ready.
Thank you. Hinda Klein here on behalf of the appellants. I'd like to reserve 5 minutes for rebuttal.
So noted.
We've raised 3 issues on appeal. The first is that the JCC erred in awarding treatment for Lowry's alleged hernia after finding that he had failed to present sufficient evidence that his work-related accident caused those hernias. Now, it's black letter law that the claimant has the sole burden of proof on causation. And in fact, the JCC, in his final order, specifically says, having considered the evidence before me, there is insufficient evidence in this record to allow the determination that the claimant has sustained hernias as a result of the workplace accident. Nevertheless, the JCC then awarded an evaluation and potential treatment of the hernias. Essentially, the JCC put the cart before the horse and found that there was no MCC between the hernia and the workplace accident, in which case the JCC erred as a matter of law in awarding treatment for that alleged condition. And I say alleged condition because the record on that is extremely limited. There is a radiographic report indicating that there were a couple of hernias discovered during a CAT scan, but that was 20 months after the accident in question.
Counsel, so I think even the claimant's attorney conceded that the order was inartfully worded, and perhaps there is some inconsistency. So you did note in the decretal portion of the order that there was an authorization for evaluation and treatment. But in an earlier part of the order, I read it to be not so definitive on the treatment part. The order said that the award was to determine if, in fact, he has a hernia or hernias, and if so, whether the workplace accident is the MCC, adding that if the accident is the MCC, then he would be entitled to treatment. Is there any room between that statement and then the decretal portion to suggest that perhaps the treatment portion wasn't truly ripe at that point?
I don't think so, because once the JCC determined that it was going to consider the PFB for both evaluation and treatment, and then found that there was insufficient evidence, at that point, it was ripe, it was decided, and the JCC's then, I guess if it were a court opinion, I would call it dicta almost, that if after an evaluation, a physician then determined that there was in fact a hernia, then the physician would be to determine whether or not there was causation. That's basically saying the physician is going to make what is the JCC's decision. And the JCC very clearly said, I don't find any evidence of causation here. And once the JCC decided that, everything else is basically irrelevant.
But isn't the context, the broader, bless you, context of that statement that The doctors had all testified that really this is not our area of expertise. He needs to be treated or evaluated by a general surgeon in order to have that information available to determine causation.
Oh, yes, they absolutely did testify like that, and the claimant's attorney at that point could have dismissed it, could have moved for a continuance, could have asked the court, the JCC, for another IME. There are a number of things that could have happened that did not. So it went to the JCC on this record where all of the medical experts testified that they were not appropriately specialized to be able to diagnose the hernias. That was the claimant's choice. And having made that choice, the claimant has to live with it. And the JCC's decision that there simply wasn't any evidence on MCC is binding on the claimant. And I would submit that anything after that basically is irrelevant. And the court was clearly in error in ordering, first of all, delegating the JCC's authority, sole authority to decide MCC, to a future physician. There's just no authority for that, and this court has reversed in 2 cases, the Gulf Life Insurance versus Giddinell and Consultants and Designers versus Brown. This court has reversed similar findings on the same basis. So we would submit that the JCC's order that basically it does not reserve jurisdiction, but basically says in the event some future doctor comes in here and says there's a relationship, then I'll think about it. Or I will let the doctor then perform that treatment. So that is a clear error of law, and we would submit that under all circumstances, this court must reverse the JCC's order with respect to the treatment. Now, having found on the record that there was no MCC at a duly noticed hearing on that specific issue, the court then couldn't grant the request for an evaluation because basically the issue was moot. If the evaluation determined that there was in fact a hernia, the JCC has already determined there's no MCC. So our second point on appeal is that this court should reverse the JCC's order with respect to the granting of the request for the evaluation. And finally, and I think this is probably part of that second issue, namely whether the JCC erred in granting an evaluation, we submit that the JCC failed to apply the correct legal standard. Because of the way this case was litigated, it was not litigated to determine whether or not an evaluation was necessary to discern whether or not the claimant's condition was related to the low back that was injured in this accident. And in fact, opposing counsel has not argued that in their brief. It was litigated as if it were a freestanding claim for benefits, and those benefits being the evaluation.
Counsel, let me ask you a pragmatic question. So if this claimant continues to have these symptoms, what is the procedural path to getting an evaluation? Can't ever get an evaluation now because of the order in which these things were decided?
That's correct. It would be
Just
res
out of
judicata,
luck.
but of course he can always get an evaluation separate and apart from workers' compensation. Just can't do it this way. And I think Judge Ray, in the MBM case that you were on, we had a similar situation where 4 years after the accident, the claimant sought an evaluation to determine whether or not head and neck condition was related to an accident, separate and apart from the right shoulder that had been accepted as compensable. The JCC awarded those benefits, but on appeal, this court reversed because the claimant failed to prove that the accident was the cause of the head and neck condition. Again, it was entirely separate and distinct from the argument that's typically made that an evaluation is appropriate where the condition may relate to the treatment or the condition already being treated. Under this court's decision in the MBM case, it's clear that the JCC erred in ruling that there was an entitlement to an evaluation under these circumstances.
Let me go back just to the order itself. Had the JCC, in your view, expressly reserved jurisdiction on the treatment, would we be here? Would you be here arguing this case?
No.
Okay. So it seems to me the motion for employer carrier's motion for rehearing was not quite as precise as the briefs. I mean, the arguments are made very clearly in the brief that the JCC went a step too far in authorizing treatment. When I read the motion for a hearing, or at least when I read the order denying it, it seemed like the JCC was perhaps either misunderstanding what the argument was or understood it and ruled for a different reason, because he really was focusing on Granger's applicability to the evaluation part of it. So maybe you can help connect the dots for me by reminding us what you argued in your motion for rehearing and how that relates to the argument you're now making on appeal.
Okay. What we argued in rehearing with respect to it was mostly regarding the JCC's order on treatment, not the evaluation per se. But it did argue that there was an inconsistency in finding that that there was no connection between the hernias and the accident, and then nevertheless ordering an evaluation and treatment. Mm-hmm. So we had brought that inconsistency to the JCC, and I think Your Honor is correct that the JCC did not appear to really understand that argument and did rely on Granger, which was a situation where only the issue of whether there should be an evaluation was before the JCC, not the issue of whether or not any potential treatment was caused by the underlying workplace accident. So Granger is simply distinguishable on those grounds. And certainly, had we been here just arguing about evaluation, that might be on point. But since the court lumped them together and said evaluation and potential treatment, the court's order should be reversed in its entirety.
Is it your position, like, had claimant had the opportunity to do this all over? I don't think this is your position. I want to make sure that a claimant would have to file a separate PFB first on the authorization for evaluation, have that go through the process, and then come back and file a separate PFB for authorization for treatment? Is that how you see the process should play out?
I believe so, yes. I mean, because it's not apparent that there was any relationship between the hernia and the actual treatment that the claimant was receiving for the low back injury, I believe that under those circumstances, there should have been a separate consideration of the evaluation first, and then if there was any kind of evidence of relationship, then a petition for the treatment.
Is that inconsistent with the efficient resolution of workers' comp benefits to have these bifurcated PFBs when, you know, in reality, each one can take months to get through the process. Is that kind of, is that process consistent with just having one PFB for both and then perhaps having the JCC reserve jurisdiction if needed? If it gets to final hearing and the authorization for evaluation hasn't already been approved or dealt with?
Well, I don't disagree that probably if there had been a single PFB and a reservation of jurisdiction, that might be more efficient. So I believe that the JCC could have done it either way, but didn't do it either way in this case. If the court has no further questions, I will reserve the remainder of my time. Thank you.
May it please the court. I'm Mark Tovey from Miami, along with co-counsel Holly Akers, who is also trial counsel on behalf of Mr. Lowry, the appellee. I think you've already gotten right to the meat of the matter, which is that the judge of compensation claims ruled that an evaluation was appropriate because there's still a question as to what is causing Mr. Lowry's complaints, the complaints that he's had since the accident. The judge references causation, and he's not really clear on whether he's saying the causation to the industrial accident or the causation to the symptoms that are resulting from the industrial accident, which the employer carrier is already treating. The doctors who have seen the claimant, none of whom are hernia specialists, have all been treating complaints that overlap with the possibility of a hernia. And that's where this is an intersection that is different from the other cases that are referenced by the appellants.
So, but counsel, would you concede that the judge's language in the decretal portion of the order that says that he is authorized to evaluate and treat claimant's condition is problematic, is a step too far, at least the treat portion?
Yes, because it's inconsistent with what the judge was explaining throughout his order and also in his order on rehearing. The judge, and I think Your Honor said it earlier, Judge Ray, when you said that the judge seemed to be focused on there needs to be an extra step. Is there a hernia? The judge never specifically found that there were hernias. He did say in his order, based upon the records and evidence, there is little dispute that claimant does in fact have a hernia or hernias, but he doesn't make that as a finding. There's a CT in the Shands records that shows the hernia, but there's also records in Shands at 550, record 550 that says there's no inguinal hernia. Then there's on the record, page 638, the Acumen MRI of the pelvis of March 16, 2023, and there were no groin hernias found there. And Dr. Rogozinski explained it when he was in his initial record. He's the authorized treating spine surgeon who was ultimately brought into this case. He first evaluated the claimant in November of 2023. And he indicated, I've asked them to retrieve the recent EMG and NCVs of the lower extremities and CT scans documenting the presence of inguinal hernias. I'm also recommending repeat MRIs of the lumbar spine and left hip. If repeat MRI of the left hip does not demonstrate any acute findings or significant hip pathology to explain his groin pain, he will likely need a general surgery consult to evaluate him for a left inguinal hernia, which would be the likely etiology of his groin pain. The employer carriers accepted lumbar radiculopathy as one of the conditions accepted on the pretrial stipulation. That's at the record at 553. Lumbar radiculopathy means that it's leaving the lumbar area and it's going other places. And Dr. Brown has a pain chart in the record on page 923 that shows that part of where the claimant is complaining about his pain is the back on the left side, and it comes around to the front in the area where you would find an inguinal hernia. So this is the condition they've been treating all along. The appellant suggests that because the judge awarded the treatment, that that's going to absolutely obliterate the claimant's ability to get an evaluation or to ever get anything related to the possible cause here because of that. That just wouldn't work specifically in this case, but it won't work in the workers' compensation system in general. Dr. Rogochinsky, after making that remark, then got those additional scans, and then he said, so my in deposition, this is at the record 205 and 206, so my diagnosis were unchanged, and in my disposition now, having reviewed these additional studies, I formulated the following opinions. With regard to the left hip pain, he's undergone previous multiple left SI joint injections, an intra-articular left hip joint injection, and PRP injection of the obturator muscle. He has continued left hip and groin pain in spite of these interventions. He has underlying pre-existing femoral acetabular impingement from a degenerative labral tear with no reported benefit from intra-articular injection. I'm getting to the good part, I promise. Current imaging does not establish any other traumatic musculoskeletal related sources for his hip pain. There remains a possibility of a left inguinal hernia as a source of his left hip pain. And in light of the conflicting imaging establishing a left inguinal hernia on CT scan, but no hernia noted on pelvic MRI or ultrasound, I recommend that he be evaluated by a general surgeon to assess whether a left inguinal hernia is present, and if it is, a pain generator contributing to his current symptoms. And that's why this case is so much similar to Granger than it is to the other cases. Because in Granger, the claimant was being treated for carpal tunnel syndrome. The physician was finding other complaints that didn't appear to be related to carpal tunnel syndrome, but the physician wasn't sure and asked for that referral to a neurologist to determine whether or not they are related. That's what's happening here. The complaints that the claimant has are the same that could be evoked from a hernia, but none of the physicians have evaluated for that. And so Dr. Rogochinsky is saying, let's go ahead and evaluate for that, and if it's there, we need to deal with it. That'll be the next step. But if it's not there, that's the end of the decision-making tree.
Well, so let's just go back to some of the language in the orders. We have the decretal portion that references treatment, and then earlier in the order, I think this is paragraph 6, the JCC says, if it is determined that the accident was the major contributing cause of any hernia, claimant would then be entitled to treatment by that general surgeon as is determined to be medically reasonable and necessary. Isn't that too putting the cart before the horse, and doesn't causation, in your mind, still need to go back to the JCC?
The JCC should make the ultimate decision on causation. It should not be, the doctor can opine on it, but the JCC should decide it. However, if the doctor opines that the major contributing cause of the condition is in fact the industrial accident, the employer carrier can say, okay, and just provide the treatment. It doesn't need to go back to the judge. It can either be decided because it's accepted or because the judge determines it's accepted. But I agree, it should not be decided unilaterally outside of the judge by a doctor.
Right. I mean, so at a minimum, I mean, just to make sure that all the parties are on the same page with respect to this order, wouldn't it be necessary to reverse or vacate the portion of the order that references authorization for treatment? Maybe there's other problems that the employer council believes that need to be addressed, but at a minimum, don't we need to have that issue addressed?
I've gone back and forth on this because it seems like the logical, reasonable way to handle this. On the other hand, there's no treatment at issue. So there's no prejudicial error that is harming the employer carrier. They're not being ordered to do anything other than provide the evaluation. At that point, they have made it clear that they don't believe, that causation has not been determined. The judge made it clear that he has not determined
So is
causation.
your argument here on causation kind of res judicata, so we won't see these parties again on this issue if there's a dispute about whether or not they can raise causation?
Well, I'm not sure. I was concerned that the res judicata is being applied here before there's been an order. That seemed to be what the appellants were trying to do. They said, okay, well, the judge didn't make a finding on causation, and so now the claimant is res judicata. And there was, no time to do anything about that. Whereas what has happened here is the judge has ruled, I'm just awarding an evaluation. And kind of and if necessary, and if related, and a lot of ands, ifs, but nothing definitive, and so there's no award there. So the employer carrier is not being required to provide a hernia surgery yet. They would have the opportunity, if treatment is recommended, to say to the judge, we don't think that it's causally related. We don't think it's medically necessary. They have all of the various options still available to them. So as far as the prejudicial effect of this order being affirmed, there really isn't one. There's no indication that the judge, well, there is some indication, but it's mixed indication that the judge actually addressed causation. The judge had an interesting exchange with counsel during the closing argument. The judge said, let me interrupt you. Whether the hernia, there is, and I apologize, this is on transcript page 69 and 70. Let me interrupt you. Whether the hernia, there isn't a hernia that's been diagnosed, and Ms. Akers, not by the authorized treating doctor, the court. So I can't make a finding that the accident's a major contributing cause of something if it hasn't been diagnosed yet, other than perhaps on the CT scan, correct, Ms. Akers? Well, Dr. Rogochinsky does address it and basically does a hypothetical and does say that the work accident is the major contributing cause. The court, if the hernia exists and he doesn't do hernias, so he's not diagnosing a hernia, correct? Ms. Akers, he listed it as one of his diagnoses. I would probably agree with you that I don't think he's qualified really to do so. The judge also indicated in his order that there was a history of the hernia. So I don't know that there's a diagnosis in this case that there is in fact a hernia. And so when the judge hasn't made a finding that there is a diagnosis, that there is a hernia, it would be, there's no prejudice as to whether or not the employer carrier is going to provide treatment. And the judge is basically saying, this issue isn't ripe because I don't even know if there's a hernia. How can I rule on causation of a condition that I don't think has been established? So for those reasons, the affirmation of this judge's order wouldn't cause a problem. And it's on page 23 where the record page 23 where the judge says included in his report is a history of the inguinal hernia.
Mr. Tobey, elsewhere in your answer brief, I'm looking at pages 14 and 17, you argue that treatment can be awarded without a finding of causation based on the hindrance to recovery theory. I was wondering if you could explain that a little bit more and whether that argument's been preserved.
Absolutely. The hindrance to recovery theory operates in a situation where there is a condition that's preventing the claimant from getting the treatment that is due to him or her by the employer carrier. If, for example, if there's out-of-control hypertension and the claimant needs to have surgery, well, the claimant's hypertension has to be under control in order for the surgery to go forward. So the employer carrier is required to treat that hypertension just to the point to get it under control so that the surgery can go forward, regardless of the cause of the hypertension. It doesn't need to have been there. If there was some indication that there is another condition here that is preventing the doctors in the Lowry case, in our case, from being able to provide the full treatment to the claimant, that hindrance would need to be removed, regardless of cause. So if there's a hernia there And if it's causing a problem, and if it's causing the pain that these doctors are trying to solve and fix, and it's not related to the accident, there's still a possibility that the judge could award that treatment to remove an obstacle in order to allow for the proper treatment to go forward.
And so are you saying that the hernia could be a hindrance to proper treatment of symptoms that are caused by something else?
I'm not specifically making that because I would agree with you that was not developed in this record. I'm saying that the judge doesn't have to necessarily find on the causation in order to have awarded treatment under certain circumstances. We're not there yet in this case. I think we're at step one, which is let's get an evaluation. Step two is going to be, after that evaluation occurs, is this condition contributing to the symptoms that the employer carrier is providing treatment for? The next step is going to be, is there treatment necessary? Does treatment need to happen as a result of this condition that's been discovered? And then the last one is going to be, what's the cause of this condition? If they're hernias, what caused them? This case, as I mentioned, Granger is the case. The difference between Dixon and Wilson is that in Wilson, this is the case where they're treating one body part, but there's no overlap. They want an evaluation. They're treating the right shoulder, but the claimant is complaining of head and neck problems. But there's no indication that there's a crossover. There's no intersection between the complaints. There's no intersection of whether one is related to the other. And that's really where Wilson doesn't mesh well with the facts of this case. Dixon we sort of addressed because that has to do with claims that are mature and ripe. And the judge in this case didn't find that the claims were mature and ripe. So the JCC ordered a general surgeon evaluation and nothing else. That's the practical effect of his order. He did order diagnostic testing that are the subject of this appeal, that are also for that purpose to determine whether or not the claimant's condition, where the pain complaints are coming from. And Dr. Keller, who was the employer carrier's IME, put in his report, this is record 528, his IME report. In his impression section, he goes through all the complaints, he goes back through the history again, and then he says, he talks about the injections that are being provided or suggested to the claimant in another part of the order. And the judge finds Dr. Keller to be one of the more persuasive doctors. And after he goes through all these injections that are about to be provided, what he says is, what these injections do not address is the possibility of an inguinal hernia. But given the mechanism, it's not likely. So Dr. Keller doesn't think it's likely, but the testing that's otherwise being provided isn't going to cover this situation. The only thing that's going to cover it is the evaluation with the general surgeon. And that's what the judge ordered. There is no prejudicial reversible error, and this court should affirm the JCC's order. Thank you.
Opposing counsel's last point is that there's no prejudicial reversible error. But as we pointed out, the way the JCC wrote his order, it absolutely delegates the issue of MCC to a physician. Now, during his argument, opposing counsel basically says that, well, if the physician does in fact find that there is a relationship there, then the carrier can pay for it. He doesn't say anything about the carriers being able to dispute MCC. And in fact, in this record, there were 2 MRIs done before the claimant went to Shands and got that CAT scan. And in the report of the second MRI, the radiologist expressly states there is no hernia. So we have a clear difference of opinion, even if it's determined later on that there is a hernia and that there could be a relationship. But opposing counsel and the JCC have basically precluded the employer carrier from litigating that by virtue of the JCC's order saying if there is a relationship, then the employer carrier can pay. There's nothing in there about coming back to the JCC and litigating causation at that point. So I would submit that it's clearly prejudicial, the way the JCC wrote the order. I don't see that there's any way to read it otherwise. And certainly, had we not appealed this, we would have been barred by the law of the case from later on being able to argue, hey, we haven't had the opportunity, we haven't had the due process to litigate this issue. So we submit that on this record, we are entitled to a reversal, not just of the order on the evaluation, but also on the order of the ultimate determination of treatment being in the hands of some unidentified physician in the future. So we respectfully request that the court reverse. Thank you.
Thank you. Thank you to both counsel for your arguments today.